I want to make sure that everybody can hear me. Can you hear me? If you give me thumbs up, that's always a good thing.
Give me thumbs up.
I can hear you.
Okay, very good.
So I'll leave you alone, but everything looks good and you're streaming, so you're good to go.
Very good.
Thank you.
Thank you. Well, good afternoon, everyone. We are here for the afternoon session of the mock trial competition. I do want to find out. We seem to be having some kind of a delayed echo. This is a very odd thing. Hopefully it won't continue. At any rate, I do want to find out if the prosecution is ready for trial.
Yes, Your Honor. We are ready to proceed.
Is the defense ready for trial?
Yes, Your Honor.
Could everybody mute themselves? That may help with the delay, the echo going. Thank you all. Next, I want to find out if the scoring panelists are ready.
This is Amanda Shepard. I'm ready, Your Honor.
Mike Administrator, I'm ready.
Skylar Gilman, Judge, I'm ready.
Thank you. For the prosecution, could the prosecution let us know who we have and which parts you're playing?
Hello, my name is Bailey Burton. I'll be presenting the opening statement, conducting the direct examination of Alex Cifuentes, and the cross-examination of Taylor Perkins.
Hello, my name is Marcus Winton. I will be conducting.
Hang on just a second. Hang on just a second. This is not going to work very well. I apologize for interrupting you, Marcus. Is it Marcus?
Yes.
We got to get this echo thing going. We got to get this off.
Now it's
Okay. So hang on just a second.
so let's see if that creates the echo. Sky, unmute yourself again. Echo back.
This
Echo
is
back.
Skylar. Oh, okay, there you go.
Okay, let me.
Your Honor, it could be because you have the live stream open on another tab on your computer.
Sorry, was I creating the echo? Are you, Sky? Go ahead and see if you're getting the echo now.
Skylar Gilman. Echo. Are you hearing it, Judge?
Okay. I took Marcus's suggestion and I closed other things. Maybe that will help.
All right. So are you getting an echo from me right now?
Not right now. So Marcus apparently is the one that we needed.
Fingers crossed.
Fingers crossed.
I'll
Okay.
put myself on mute and hang out for a minute.
Sounds good. Thank you. Okay. Bailey, I'm going to come back to you because once the echo started, I didn't get all of the positions that you were going to be doing. I got the opening and I got the direct of Alex Suentes. Can you tell me others?
And then I will be also conducting the cross-examination of Taylor Perkins.
Thank you. Marcus?
Hello, my name is Marcus Winton. I will be conducting the cross-examination of, I will be conducting the direct examination of Ms. Kyle Kuzak and the cross-examination of Professor Van Owen.
Thank you.
Good afternoon, Your Honor, members of the jury. My name is Angel Hernandez, and I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Ms. Avery Becker, as well as presenting the closing argument for the prosecution. May our witnesses now introduce themselves.
Please, thank you.
Good afternoon, Your Honor. My name is Paige Funchy, and I am Detective Jordan Markowitz.
Good afternoon, Your Honor. My name is Sherby Rangel, and I am Alex Fuentes.
Good afternoon, Your Honor. My name is Andrea Hernandez, and I am Kyle Kuzak.
Thank you. For the defense.
Hello, my name is Johnny Flanagan, and I will be doing the opening statement for the defense, and I will be conducting the direct examination of Taylor Perkins and the cross-examination of Alex Fuentes.
And my name is Asher Goldberg, and I will be conducting the cross-examination of Detective Jordan Markowitz and the direct examination of Professor Van Owen.
My name is Connor Flamenco. I will be conducting the direct examination of Avery Becker and the cross-examination of Kyle Kuzak. I'll also be giving the closing argument for the defense.
May our witnesses introduce themselves?
Please.
Hello, my name is Bryn Berry, and I am Avery Becker. My name is Ellie Burton, and I am Taylor Perkins.
My name is Joel Doherty, and I am Professor Blake Van Owen.
Thank you. I do want to remind everyone that we won't be having any recesses. Do any of the scoring panelists have any reason to be biased in judging either of the teams?
I do not, Your Honor.
No, ma'am.
No, Judge.
Thank you. I do want to remind all of the teams that any disputes arising out of the competition must be reported in accordance with the competition rules. I also want to remind everyone that their compliance with the time requirements will be considered in scoring individual performances. At this time, I'm going to swear in all of the team members, the gallery, the scoring panelists, and the witnesses. For the team members, if you'd all please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Thanks. And the witnesses, if you please raise your right hand. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes.
Thank you. For gallery members, including teachers, attorney coaches, family members, and friends, if you please all raise your right hands as well. Do you all promise to represent yourselves as positive role models and to behave in a manner that exemplifies the ethical and professional sportsmanship during and after this mock trial round?
Yes, Your Honor.
Yes, Your Honor.
Thank you. And scoring panelists, finally, if you please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Thank you all. With that, opening statements.
Your Honor, before I begin my opening statement, we do have a couple housekeeping matters we would like to address.
Please, thank you for reminding me about preliminary matters. Go ahead.
First, we would like to clarify that pursuant to Rule of Competition 7.4, for the purposes of our online competition, exhibits that are displayed on the screen will not be shown to the jury unless we specifically request to publish. Exhibits may be shared on the screen for purposes of identification prior to admission.
Yes, that is correct.
Also, additionally, while each of our attorneys and witnesses have made efforts to be in a setting with the best internet capabilities possible, if at any point the court cannot hear or see us, you should feel free to interrupt us at any time.
Thank you. I will do so.
Also, Your Honor, for the record, all witnesses will be present for the trial today and may not be sequestered pursuant to Rule of Competition 5.3.1.
Yes.
We would also like to request that the stipulations and jury instructions be constructively read into the record.
Any objection from the defense?
No objection, Your Honor.
Thank you. They will be so done.
That is all.
Any preliminary matters from the defense?
Yes, Your Honor. We are doing this for our high school, and so periodically there may be bells ringing. When that happens, we'll mute ourselves until it's over.
Understood. Thank you for letting us know.
Thank you.
With that, opening statements.
May it please the court.
Yes.
A knife in the back. On March 6, 2020, Avery Becker made a rash decision and confronted her coach about their disagreements in the past. But like most rash decisions, things didn't go as planned, and later that day, Mackenzie Brackman was found dead. However, this type of decision wasn't unusual for Miss Becker. In fact, just earlier that year, Miss Becker had made another rash decision and wrote Worst Attorney Award across the hood of her coach's beloved Porsche. This is just one example of Miss Becker's rash personality. However, throughout this trial, this topic will be brought up time and time again, as Miss Becker's previous teammates and even best friend have previously described this trait in their affidavit. But let's talk about the day the murder took place. On March 6, 2020, Avery Becker and Taylor Perkins, who claimed to be Miss Becker's best friend, skipped school to look for Miss Becker's lost phone. Miss Becker claims to have lost her phone the night
Ms. Burton, I can't hear you right now.
Your Honor, are you able to hear me?
I now can. I couldn't there for a moment, and so I was trying to get your attention. Thank you. Go ahead.
Could you remind me of where it cut out? Or where would you like me to begin?
You were talking about the night of the incident.
Okay. Miss Becker claims to have lost her phone just one night before the murder took place, even though it traces her to being near the victim's house at the time the murder took place. This is also the same phone that Miss Becker had previously used to admit her plans of breaking into Mr. Brackman's house while he was at work to former teammate Alex Cifuentes. During this trial, the defense may try to distract you with alternate theories and even the victim's personality himself. However, as the prosecution, we have the burden of proof in today's case. We have to prove beyond a reasonable doubt on March 6, 2020, Avery Becker committed the offense of second-degree burglary and murder in the first degree. This means we have to prove on or about March 6, 2020, Avery Becker unlawfully and willingly committed the offense of second-degree burglary, and in the course, the offense of the death of Mackenzie Brackman occurred by Miss Becker. For us to prove our case beyond a reasonable doubt, we must not eliminate all possible doubt. After all, everything in life is open to some possible or imaginary doubt. A reasonable doubt is such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves, which is why, at the end of today's case, there will be no reason to hesitate. You'll hear from Detective Jordan Markowitz, who is a certified homicide detective with Denver Police Department. During her testimony, she will walk you through where Miss Becker was on the day the murder took place based on her cell phone records, even though Miss Becker claims to have lost her phone just one day before the murder took place. You'll also hear from Kyle Kuzak, who's a certified reconstructive investigator. And during her testimony, she will walk you through the procedure of gathering evidence and examining the residence. Lastly, you'll hear from Alex Cifuentes, who's a former teammate of Miss Becker and the one she previously admitted her plans of breaking into Mr. Brackman's house to before the murder took place. After hearing all of this evidence, there will be no reason to hesitate. My co-counsel will ask you to return with a verdict of guilty. Thank you.
Thank you. For the defense, any opening statement?
Yes, Your Honor. May I proceed?
Yes. And could you tell me your name one more time? Mr. Flanagan, is that right?
Yes, Johnny Flanagan.
Thank you, Mr. Flanagan. Go ahead.
May it please the court. Good morning, Your Honor, ladies and gentlemen of the jury and opposing counsel. My name is Johnny Flanagan, and I, along with my colleagues, represent Miss Avery Becker and her defense. Miss Becker stands here today falsely accused for a crime of murder. Make no mistake, there has been a murder and someone out there did it, but Miss Becker is not that person. When the prosecution presents their evidence, you will find that it is all circumstantial and will not meet the burden of proof necessary to prove that Miss Becker is guilty. As J.K. Rowling said, always the innocent are the first victims. So it has been for ages past, and so it is now. Ladies and gentlemen of the jury, Miss Becker is one such innocent victim. A victim of a sloppy police department who would rather incarcerate an innocent civilian quickly than take the time to do their job correctly and catch the actual killer. At the end of this trial, we will ask that you render my client not guilty, which is the only correct verdict for this case. Today, you will hear from 6 witnesses. 3 will attempt to prove without a reasonable doubt that Avery Becker is guilty of what she's accused, a task they will not be able to fulfill with the evidence they can provide. And 3 will testify to the innocence of Avery Becker and the sloppiness of the police department. You will hear that Detective Markowitz falls short of completing an accurate investigation and that his police work was sloppy at best. From Kyle Kuzak, you'll hear that even she admits that she would prefer more physical evidence on the scene of the crime. And from Alex Fuentes, you'll hear that Avery Becker allegedly sent text messages to her on a phone that Avery did not even have in her possession at that time. Following the prosecution's witnesses, you will hear from Avery Becker. You will hear from Ms. Becker that the evidence brought forth by the prosecution is inadequate to prove without reasonable doubt that she was in any way involved with the murder of Mr. Brackman, and that she not only has an alibi, but also has a witness to confirm that her alibi is honest. Our second witness will be Taylor Perkins. She will testify that on the day of the murder, she was with her best friend, Avery Becker, searching for Avery's phone far away from the scene of the crime. Lastly, our third witness will be Blake Van Owen, a private investigator, professor, and expert in police practices. He will illuminate the flaws and inconsistencies of the prosecution and help to prove that not only is Ms. Becker innocent, but the idea of prosecuting her as guilty is laughable. The inadequate evidence that will be provided by the prosecution and the honesty and sincerity from the defense should be reason enough to prove the innocence of Ms. Becker. At the conclusion of this trial, the defense will ask that you find our client not guilty. The prosecution will not be able to provide the proof necessary to convict our client. After all, as the prosecution has already so kindly reminded us, they are required to meet the burden of proof to prove without any reasonable doubt that our client is guilty. A verdict of guilty would not only be an injustice, but it would be a travesty and a tragic failing of the American justice system. Thank you.
Thank you. Your first witness for the prosecution.
Yes, Your Honor. The prosecution would like to call Detective Jordan Markowitz to the stand.
All right. At this time, you are under oath. Please proceed.
Your Honor, before I begin, I would like to ask, can you see and hear me okay?
I can see you. You're a little bit, it's not as easy as it was when you were closer, but you're fine. Go ahead.
Okay. If at any point those conditions should change, please let me know.
I will. Thank you. And that is better. Go ahead.
Good afternoon. Could you please introduce yourself to the jury?
Good afternoon. My name is Detective Jordan Markowitz.
Detective Markowitz, what is your involvement in today's case?
I am the lead detective assigned to the murder of Mackenzie Brackman.
What education and/or experience did you receive to become a detective in the first place?
Well, I've worked with the Denver Police Department for 13 years, 7 of which I've been a homicide investigator, and I took a specialized course in cell phone data technology, and I received my certification in that.
Well, what kind of expertise do you have in respects to cell phones?
Well, I learned how to analyze forensic data from cell phones, the contents of cell phones, the contents of cell tower data analysis, as well as CDRs.
And how often would you say that you use this certain area of expertise?
I use it almost constantly in my investigations.
Your Honor, at this time, I would ask that Detective Jordan Markowitz be recognized as an expert in the fields of homicide investigation with an emphasis on cellular phone technology.
Any objection?
Yes, Your Honor. I object to lack of foundation for admitting the witness as an expert in being a homicide detective.
Any response?
Your Honor, in pursuant to Rule 702, a witness can be tendered as an expert if they present proof of their education or experience or training. As Detective Markowitz has to speak to her own education and experience, she should be allowed to be an expert in such fields.
At this time, I'll allow the expert designation, and I do accept you as an expert in the areas tendered. Go ahead.
Yes, Your Honor. Detective, focusing on the case, when exactly did you arrive at the crime scene?
I arrived at the scene of the crime around 2:20 p.m. when it had already been secured by uniformed first responders.
And having seen the crime, what exactly were your first impressions?
Well, I immediately noticed that there was a video doorbell system installed in the house, and that the victim was laying partially inside of his house and partially outside of his house in a pool of blood.
You have just mentioned that there were cameras found around the house. Was anything downloaded from these cameras later in your investigation?
Yes, in my investigation, I downloaded 4 videos total from these cameras.
Your Honor, at this time, I would ask that our trial technician display exhibits 10 and 13 for purposes of identification.
So allowed. Go ahead.
I apologize. You cut out what exhibits?
Exhibits 10 and 13, Ms. Mintz. And detect that these videos take a while to pull up. We'll take them one at a time. Detective, do you recognize Exhibit 10?
Yes, I do.
And would you say that this is a fair and accurate copy to the best of your knowledge?
It is.
And now 13, Ms. Mintz.
Your Honor, I object to my opposing counsel playing the video before they are admitted as videos before they are admitted as evidence.
For the purposes of the competition, they're being presented so that a foundation can be laid. They're not being considered by any of the jurors. In fact, the jurors would be admonished that they're not to consider this. This is just for the purposes of identification. Thank you, though, Mr. Goldberg. Go ahead, Mr. Hernandez.
Your Honor. Now, Detective, do you recognize Exhibit 13 as Ms. Mintz placed it out?
Yes, I do.
And would you say that this is also a fair and accurate exhibit to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I would ask that Exhibits 10 and 13 be admitted into evidence.
Was it 10 or 11? I apologize. Perhaps I got the number wrong.
10, Your Honor.
All right. Any objection?
Yes, Your Honor, lack of foundation.
Any response?
Your Honor, as Detective Markowitz has laid significant foundation saying these were videos that were extracted from the Ring doorbell system cameras. That is the sole amount of foundation that is needed to admit such exhibits.
Anything else, Mr. Goldberg?
I stand by my objection.
There has been adequate foundation laid at this time for the admission of Exhibits 10 and 13. They will both be admitted. Go ahead.
Yes, Your Honor. Now, Detective, what exactly is this footage able to reveal to the jury? Oh, and excuse me, Your Honor. May I also publish these exhibits to the jury?
Yes.
Thank you, Your Honor. And now, Detective, what exactly are these exhibits able to display to the jury?
Exhibit 10 shows an intruder approaching a locked front door to Mackenzie Brackman's house, and Exhibit 13 is a video of them exiting from the front door.
Thank you, Ms. Mintz. That's all. Now, Detective, were you able to obtain anything else from the victim's phone?
Yes, I found an extensive amount of emails and text messages relating to something called mock trial, which I now know is a high school program relating to law.
Did you look any further into this mock trial program?
Yes, I did. I received student records from the Colorado High School, which is the school that Mr. Brackman coached for, and I looked into the students, though I was originally dissuaded from thinking it had anything to do with the case.
And were you able to contact anyone from that registry that you were able to obtain through the school?
Yes, luckily, one of the first people that I contacted, Alex Cifuentes, gave me a large break in the case.
And how exactly was Ms. Cifuentes able to lead you to one of the greatest breakthroughs in your investigation?
Well, Ms. Cifuentes gave me some information to another student, Avery Becker, and their rocky relationship with Mackenzie Brackman.
Did you bring Ms. Cifuentes into an interview at any time in your investigation?
Yes, I did.
And what information were you able to extract from such an interview?
I received notice that Mackenzie Brackman had kicked Avery Becker off of the Team 1 for Colorado High School, and due to an incident between them, Avery Becker had asked Alex Cifuentes for help getting back on the team.
Objection, Your Honor, hearsay.
Any response, Mr. Hernandez?
Your Honor, could opposing counsel clarify their objection?
The witness is talking about something that they heard from another person that was not in this trial, or an out of court statement.
Given that, Your Honor, may I respond?
Yes. Please.
This is hearsay, however, it is not being used to prove the truth of the matter asserted, but rather the effect on the listener.
In what way?
Miss Detective Jordan Markowitz will be expanding on her view of what she was able to understand from the interview to form her ultimate conclusion as an expert.
At this time, the objection sustained. I need some additional foundation as far as what the opinion would be for this to be relevant to that opinion.
Yes, Your Honor. Now, Detective, you were able to receive an interview with Detective Jordan Markowitz, with Ms. Cifuentes, excuse me, sir, correct?
Yes, I did interview Alex Cifuentes.
And in that interview, what exactly was brought up?
I was made aware of another student on the mock trial team, and their relationship with Mackenzie Brackman was rocky at best.
And Your Honor, at this time, I would ask that Exhibit 14 be shown for purposes of identification.
Yes.
Detective, do you recognize this exhibit?
Yes, I do.
What exactly is it?
This exhibit is the photos of the text messages Alex Cifuentes received from Avery Becker and forwarded to me.
And is it accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I would ask that Exhibit 14 be admitted into evidence.
Any objection?
Yes, Your Honor, to lack of foundation and hearsay.
Any response, Mr. Hernandez?
Yes, Your Honor. Whilst this exhibit is in fact hearsay, it falls under the exception 801D2, as the statements labeled in gray are made by a party opponent, that party opponent being Ms. Becker. And as for the statements made by Ms. Cifuentes, they're simply being used for context to those of Ms. Becker. As for the lack of foundation objection, Detective Jordan Markowitz has been able to speak to how exactly he was able to receive such an exhibit, and in pursuant to Rule 702, as Detective Markowitz is an expert, he can rely on otherwise inadmissible evidence to form his conclusions.
On the basis of foundation, the objection is sustained. On the basis of hearsay, the objection would be overruled. You need to lay some additional foundation.
Yes, Your Honor. Detective Markowitz, what exactly was Ms. Cifuentes able to offer you in terms of information from the interview?
Ms. Cifuentes made me aware of a conversation between herself and Avery Becker about Avery Becker's intentions to break into and trash the victim's home.
And at any point, was Ms. Cifuentes able to bring you a copy of said conversation?
Yes, Ms. Cifuentes did send me a copy of the conversation.
Your Honor, I would now ask that Exhibit 14 be admitted on the grounds of a now adequate amount of foundation.
Mr. Goldberg?
No objection, Your Honor.
Exhibit 14 is admitted.
Thank you, Your Honor. Now, Detective, what exactly does Exhibit 14 display to the jury?
Well, in Exhibit 14, there is a text from the person labeled Avery Becker, which states their intention to break into and trash the victim's residence, stating that if they were angry about what the defendant had done to their car, they would be more angry about what the defendant would do to their house.
Now, with the knowledge of the defendant, how were you able to continue with your investigation?
Well, I immediately reached out to see if I could interview Avery Becker thoroughly. However, they had acquired a lawyer and I was denied access.
Well, were you able to obtain the detective's phone with the defendant's phone, as you do in fact have a certain area of expertise in cellular phone technology?
I was not able to obtain the phone itself. I was informed that the defendant had indeed lost it. However, I was able to get the defendant's phone number, and through that, I contacted their service provider to get call detail records, which can help show the location of the phone at a certain time.
Your Honor, at this time, I would ask that my trial technician display exhibits 15 and 16 for purposes of identification.
Yes, that would be fine.
Ms. Mintz? Detective, do you recognize exhibit 15?
Yes, exhibit 15 is a diagram that I made showing the locations of the 3 cell towers that Avery Becker's phone pinged off of on March 6th.
And what about exhibit 16?
Exhibit 16 is the same diagram. However, I have drawn the most likely route that Avery Becker's phone would have taken during the times that it interacted with the towers.
Your Honor, as Detective Margaret's just spoken to her knowledge of these diagrams, I would ask that they be admitted into evidence.
Mr. Goldberg?
I object to the admission of 16 as, on the grounds of hearsay.
Any response, Mr. Hernandez?
Yes, Your Honor. As Detective Jordan Markowitz was simply using his expertise in cellular phone technology, he used that expertise to form an interpretation of the best line that Ms. Becker would have taken to arrive at Mr. Brackman's house. And as such, it is admissible under 702, given that Ms. Markowitz is an expert and can rely on otherwise inadmissible evidence.
The objection is based on hearsay. On that basis, the objection is overruled.
Yes,
Exhibits 15 and 16 will be admitted.
Detective, could you give a description of Exhibit 15 to the jury?
Of course. Exhibit 15 shows the 3 cell towers that Avery Becker's phone interacted with on the day of March 6th throughout the time of the murder. And these cover the area from Avery Becker's house to Mr. Brackman's house.
And Detective, if you could, Ms. Mintz, if you could focus on Exhibit 16 for the jury. Detective, what exactly was this exhibit able to portray to the jury?
Exhibit 16 shows a dotted blue line, which indicates the path that Ms. Becker would have most likely taken to go from their house to the victim's house during the time that the phone interacted with the cell towers.
Thank you, Ms. Mintz. You may now stop sharing your screen. Now, Detective Markowitz, with the accumulation of all the evidence that you have just listed and the rest that you use in your investigation, who would you say that this evidence points to?
The evidence points to Avery Becker.
Thank you, Your Honor. No further questions.
Mr. Goldberg?
May I proceed with my cross-examination?
Yes, please.
Detective Markowitz, you claim pictures of blood drops and spatters were taken at the crime scene, correct?
Yes, there were pictures taken of the cast-off.
But you lost those pictures, didn't you?
No, the files were corrupted.
And you only took one copy of each of those pictures?
Unfortunately.
And is it not a good idea to take multiple copies of a picture in case one of them is lost or corrupted?
Generally, yes, and I am upset that I did not think to do that at the time.
And no one saw those pictures other than you, correct?
No, that's not true. Kyle Kuzak did see them as well.
Now, you said in your statement that the fact that Brackman did criminal defense work raised the specter that this could be the work of a disgruntled Sorry, would you like me to repeat the question?
Please.
Yes, I'm sorry about the bell.
So, you said in your statement that the fact that Brackman did criminal defense work raised the specter that this could be the work of a disgruntled ex-client, right?
Yes, it did raise the concern.
Did you ever, yes or no, investigate this theory?
I did.
So you investigated ex-clients of Brackman?
I did. There wasn't sufficient evidence enough to bring one in for suspects.
Now, did you ever personally view the texts in Exhibit 14?
Yes, I did.
Did you view them on the phone that they were received on?
No, I viewed them from the pictures that I was sent.
So can you say with absolute certainty that those texts were authentic?
I can say with the most certainty that, in my opinion, they are completely authentic. However, there's always a small chance.
And you said in your statement that a cell phone does not always connect to the nearest cell phone tower, correct?
No, it does not necessarily.
And you also said that you do not absolutely know that Becker was on the path to Brackman's house, correct?
I'm not sure if that is the correct path that Ms. Becker took. However, I do know that she was at Mr. Brackman's house.
And you also say that it's absolutely clear that Avery Becker went to Mackenzie Brackman's house on the day of the murder, correct?
It is, yes.
But if you do not absolutely know that Becker's phone was in the vicinity, then is it possible for you to be for it to be absolutely clear that Avery Becker killed Mackenzie Brackman?
I'm not sure what you mean. I don't think I heard all of your question.
Is it possible for you to absolutely know that Avery Becker was at Mackenzie Brackman's house if you don't absolutely know that their phone was in the area?
Well, we do know the phone was in the area, so therefore it does make it very clear that Mackenzie Brackman had Avery Becker at their house at that time.
No further questions, Your Honor.
Any redirect, Mr. Hernandez?
May I inquire as to how much time I have remaining, Your Honor?
Yes.
Ms. Mintz?
You have 13 minutes and 50 seconds remaining.
Given that, Your Honor, no redirect.
All right, your next witness.
Your Honor, the prosecution calls Alex Cifuentes to the stand.
Thank you. You are under oath at this time. Please proceed.
Good afternoon. Please introduce yourself to the jury.
Hi, my name is Alex Cifuentes.
Ms. Cifuentes, could you please explain how you are connected to the case today?
Avery and I, we are both on the Colorado High mock trial team.
And how long have you been on the team together?
We both joined freshman year. Actually, it was Avery who got me into joining the team.
So how would you describe your time with Ms. Becker?
Avery and I we never really saw eye to eye. She was a type person on mock trial. She was a type person who doesn't get to practice on time and doesn't put in any work for the team. I, on the other hand, take mock trial very seriously and try to succeed. I'm always getting on my direct and cross examinations right when Coach Brackman assigns them, and well, Avery doesn't.
And how would you describe your time on mock trial?
Like I said, I take mock trial very seriously and try to succeed. Avery succeeds without us trying as hard as the other members, which always made Coach Brackman mad.
On that note, could you please describe Avery and your former coach's relationship?
Yes, Avery never really got along with Coach Brackman. They're always arguing about Avery's lack of commitment towards the team and how she is never prepared for tournaments and sometimes even practices. Things got worse after the incident with Coach Brackman's car.
And what happened at practice before this incident?
We had a competition the weekend before, and Avery had gotten the Best Attorney Award at practice. After practice, excuse me. Coach Brackman and Avery were arguing about how she shouldn't be confusing good showmanship with good lawyering and saying stuff like she really didn't deserve that award.
And could you explain the incident with your coach's car more in detail?
After practice, we usually write our ideas down while leaving. I saw Avery grab a permanent marker. She vandalized Coach Brackman's car, writing words attorney would across the hood.
And how did that victim react to this?
Well, for starters, Coach Brackman kicked Avery off the team, and later that day, she texted me asking me if I could talk to Coach Brackman about letting her back on the team.
Your Honor, at this time, I ask that our trial technician please pull up Exhibit 14, which has previously been admitted into evidence.
Yes.
Please direct your attention to Exhibit 14. Do you recognize this exhibit?
Yes, I do.
Could you tell the jury what these are?
These are the messages Avery sent to me after I let her know that Coach Brackman wasn't interested in letting her back on the team.
And these are accurate to the best of your knowledge?
Yes, they are.
Ms. Fuentes, I seem to have not been able to hear your answer. Could you please re-respond?
Can you please ask the question again?
These are accurate to the best of your knowledge?
Yes, they are.
So to clarify for the jury, these are the messages you received from Ms. Becker, correct?
Yes, after letting her know that Coach Brackman wasn't planning to let her back on the team.
And she was texting you because she wanted to have you talk to Mr. Brackman, correct?
Yes, she wanted me to talk to Coach Brackman about letting her back on the team.
And did you talk to the victim?
Yes, I did, but I guess he wasn't interested in letting her back on the team. I'm sorry.
After talking to your coach, did you talk to Ms. Becker again?
I texted her, letting her know that he wasn't interested in letting her back on the team. Avery seemed really angry, and she was saying stuff like what she did to Coach Brackman's car was nothing.
And did Ms. Becker say anything else about what she was planning?
I asked her what she meant by that, and she was angry and didn't say much, but she said that she was going to break in and trash his house.
And was that the last you heard from Ms. Becker?
Yes, it was. After the incident, we all went our ways.
Let's talk about your interview with Detective Markowitz. He interviewed after the incident, correct?
I'm sorry, you cut out. I did not hear that.
After the incident, you met up with Detective Markowitz, correct?
Yes.
Let's talk about your initial interview. Did you share these messages?
I had mentioned the messages to Detective Markowitz, but I didn't have my phone on me. So she asked if I could send screenshots to her when I got home.
Why didn't you have your phone with you?
It was a really old phone and didn't stay charged for so long, so I just forgot to grab it on the way out the door.
And when you got home from the interview, did you send the screenshots of your messages with Ms. Becker?
Yes, I did. I sent the screenshots to Detective Markowitz and asked if there was anything else she needed, but I guess there wasn't, and I didn't hear too much from her again.
And why didn't you turn your phone into the police?
My parents offered to bring the phone to the station the next day, but I guess it wasn't necessary.
Finally, Ms. Fuentes, after your brief conversation with the defendant containing Ms. Becker's words, break in and trash, do you believe Ms. Becker was angry enough with your former coach to make a rash decision?
Objection, speculation.
Any response?
Your Honor, this is not speculation pursuant to Rule 701. This is proper lay witness testimony rationally based on the witness's perceptions and observations.
The objection sustained.
Would you like me to repeat the question?
Yes, please.
Ms. Cifuentes, after your brief conversation with the defendant containing Ms. Becker's words break and in trash, do you believe Ms. Becker was angry enough with your former coach to rash
Objection.
decision?
I believe that you said my objection was sustained, correct?
I did, yes.
Oh, I'm sorry, Your Honor. My internet cut out. I thought you said it was overruled. No further questions.
Mr. Flanagan,
May I begin my cross-examination?
please.
Thank you. Is it correct that you saw Avery Becker and Taylor Perkins at the Fry Shack on March 5th, 2020?
Yes, I did. We were all gathered there.
And please respond with yes or no. Is it correct that you did use Avery Becker's phone on that day?
Yes,
And it's also correct that you never showed the police your physical phone with the text messages Avery allegedly sent to them.
I'm sorry, can you rephrase the question?
Is it correct that you never showed the police the physical phone with the text messages Avery allegedly sent to them?
No, I forgot to grab my phone before the interview with Detective Markowitz.
Would you say that you're an average phone user?
I guess, yeah.
Do you think that it's odd that you might forget to bring your phone, especially on such an important day?
It was old, and we were in a rush. So
Do you also acknowledge that it's fairly simple to Photoshop and fake text messages?
yeah, but I wouldn't do that, to be honest.
Thank you, Your Honor. No further questions.
Any redirect?
No, Your Honor.
Thank you. You're finished. We can take the exhibit down. Thank you. Your next witness.
Your Honor, the prosecution calls Ms. Kyle Kuzak to the stand.
Thank you. Ms. Kuzak, you will continue to be under oath. Go ahead.
Before I begin, can you hear and see me all right?
I can. Thank you.
Good afternoon. Could you please introduce yourself to the jury?
Good afternoon. My name is Kyle Kuzak.
Ms. Kuzak, why are you here today?
I worked as a crime scene reconstruction investigator, or CSR, with the Denver Police Department, and I reconstructed the murder of Mr. Brackman.
So, Kyle Kuzak, I'm having a little bit of a difficulty hearing you. So if you could get a little bit closer, maybe turn up the volume. There you go. Thank you. Go ahead.
Your Honor, would you like me to re-ask the question?
No, you can keep on going. I just was having a little bit of a difficulty. Thank you. Go ahead, Mr. Winston.
How did you obtain this position?
I have over 19 years of experience with crime scene reconstruction. I've worked on everything from burglaries and home invasion to domestic violence and homicide.
Your Honor, at this time, I ask that Ms. Kyle Kuzak be tendered as an expert in the field of crime scene reconstruction.
Any objection? I can't hear you. You're on mute.
Oh, yeah, sorry, I couldn't.
There you go.
Yes, Your Honor. I don't believe that proper foundation has been laid for Kyle Kuzak as an expert.
Your Honor, may I respond?
Yes, Mr. Whitten.
Ms. Kuzak has just testified to have had 19 years of experience with crime scene reconstruction. That more than qualifies her to testify as an expert in that field.
Perhaps there does need to be a little bit more foundation. If you could, please lay it. The objection at this time is sustained.
Thank you, Your Honor.
Ms. Kuzak, Ms. Kuzak, could you tell us about your training that you received to become a CSR?
I went through a lot of training. I am not a police officer. I've worked with the Denver Police Department, and as I said, I have 19 years of experience I've experienced it all. I've seen different types of crimes, like I said, burglaries, I've seen it all, home invasion, homicide.
Ms. Kuzak, during those 19 years of experience, do you think that you have knowledge that would help the trier of fact in today's case?
Yes, of course I do.
Your Honor, I again ask that Ms. Kyle Kuzak be tendered as an expert in the field of crime scene reconstruction.
Any objection?
Yes, Your Honor. I don't believe that the expert Kyle or the witness Kyle Kuzak has evidence of where they even got education. And if they only have the only actual thing that they really have to bring forth with them being an expert is their own testimony.
Your Honor, may I respond?
Yes.
So as pursuant to Rule 702, which is what allows experts to be qualified, a witness simply needs either experience, training, or specialized knowledge that would be helpful to the trier of fact for them to be qualified as an expert in that field. Ms. Kuzak has just testified to have had both experience and knowledge of crime scene reconstruction, all of which would be helpful in the trier of fact in today's case, as it would allow the jury to better experience what actually happened during Mr. Brackman's murder, and thus it would be extremely probative to the jury.
At this time, the objection is overruled. I do accept you as an expert in the area of crime scene reconstruction. You'll be allowed to express expert opinions in that area. Go ahead, Mr. Wooten.
Ms. Kuzak, could you walk us through how you prepare for a reconstruction?
Absolutely. I work under a 5-step process: recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and finally, reconstruction.
Could you walk us through that process step by step?
Of course. Most of my process, I'm told, is very boring, but I love it. Mostly I'm collecting, organizing, and analyzing the evidence I have access to. I find that spreadsheets and flowcharts are especially helpful when it comes to the organization part of my analysis.
Could you explain to the jury what this organization looks like?
Yes, of course. The very first thing I do is I create a witness tracking spreadsheet. This allows me to compare witnesses' stories to the physical evidence. I then create a timeline. The timeline helps me not get lost into too much detail and focus on the big picture.
What evidence did you review in preparation for today's case?
I reviewed police reports, photographs, and 4-ring security camera videos.
Now, Ms. Kuzak, could you walk us through what happened on March 6th?
Yes, let's start here. On or about March 6, 2020, a person matching the physical description of Miss Becker approached the front porch and attempted to go in through the front door of the victim's residence.
What happened after the intruder attempted to enter?
Since the front door had been locked, the intruder had gone to the back through the south side of the residence and past a fence gate and found a sliding glass door in the back.
What did they do when they found this glass door?
Well, they opened the sliding glass door and they proceeded into the residence.
Your Honor, at this time, I ask that my trial technician display Exhibit 2, 3, 4, 5, 8, 9, 17, and 18.
Yes.
Ms. Mintz, if you could just scroll through the exhibits for Ms. Kuzak. Ms. Kuzak, do you recognize all of these exhibits?
Yes, I recognize all those exhibits.
And are they all fair and accurate to the best of your knowledge?
Yes, they are all fair and accurate.
Your Honor, at this time, I ask that exhibits 2, 3, 4, 5, 8, 9, 17, and 18 be admitted into evidence.
Any objection?
Yes, Your Honor. I do not believe that beyond recognition, these exhibits have had proper foundation laid upon.
Your Honor, may I respond?
Yes.
The witness has already testified to being familiar with all evidence in today's case and having had reviewed all evidence in today's case.
The objection is sustained. Understanding the response from Mr. Winton, at this time a foundation hasn't been laid that these documents are in fact evidence in this case.
Ms. Kuzak, Ms. Mintz, could you pull back to exhibit 2? Ms. Kuzak, do you recognize this exhibit?
Yes, I recognize that exhibit.
Have you examined this exhibit before trial?
Yes, I think, oh.
Is this exhibit fair and accurate to the...
Yes, it's fair and accurate.
And Ms. Mintz, can you go to exhibit 17?
I'm sorry, Mr. Winton, did you ask for exhibit 2? Was that 2?
Yes, exhibit 2 was the one that was being shown on the screen.
Okay, thank you.
Do you recognize this exhibit? Ms. Kuzak, are you there?
Yeah. Which exhibit are we talking about?
Ms. Kuzak, do you recognize exhibit 17?
Yes.
Your Honor, there appears to be an issue with Ms. Kuzak's Wi-Fi and sound. I ask that time be stopped so that she may remedy this issue.
Yes. Ms. Kuzak, can you say something? Because we're having there's a bit of an issue hearing you.
Can you hear me now?
Not very clearly.
Ms. Mintz, you can take down the exhibits.
Your Honor, if I may, Ms. Kyle Kuzak and I are in the same residence, and as such, I would be pleased if she could use my computer to finish out the examination.
I don't have an issue with that. Any objection from the defense?
No objection.
Okay. So Ms. Kuzak, if you could go switch places with Attorney Hernandez. Time will begin with the next question. Go ahead, Mr. Winton.
Ms. Kuzak, could you walk us through your reconstruction?
I'm sorry, could you repeat that one more time?
Absolutely. Could you walk us through your reconstruction?
Yes, my reconstruction began with looking through the ring videos and looking at the exhibits.
What did you determine from these exhibits?
I concluded that because as a result of using through the ring cameras, Mr. Brackman had been alerted of the intruder, and once the intruder had entered, the victim, went to the kitchen and grabbed a knife in order to defend himself.
What happened after the victim grabbed the knife?
Once the victim had grabbed the knife and the intruder had been aware of the knife, both the victim and the defendant had been in some sort of struggle in order to keep or obtain possession of the knife.
Objection, these facts are not in evidence.
Mr. Whitten?
Your Honor, could you ask opposing counsel to clarify their objection? I don't understand what facts aren't in evidence.
Mr. Promenko?
Yes, I do not believe that the evidence that Ms. Kuzak is talking about have been admitted as evidence yet.
May I respond?
Yes.
Ms. Kuzak is testifying as to her expert opinion of what happened during the murder of Mackenzie Brackman. Therefore, we do not need to admit this evidence as it is expert witness testimony.
The objection's overruled. Go ahead.
Ms. Kuzak, what happened after the intruder took possession of the knife?
Well, the intruder had since the victim and the intruder were in close contact, and when the intruder had obtained possession of the knife, the intruder went over the victim in a bear hug type motion and stabbed the victim through the shoulder, hitting the top of the heart.
Are you aware of Professor Van Owen's conclusions?
Yes.
Do you think these conclusions are valid?
Not exactly.
Thank you, Your Honor. No further questions.
Mr. Promenko?
Yes, Your Honor. May I proceed with cross-examination?
Yes, please.
Good afternoon, Ms. Kuzak. So you visited the scene of Mackenzie Brackman's death, isn't that right?
Yes, of course I did.
And you arrived at the scene after it had been processed by other people, including the crime lab, isn't it right?
Yes.
So some of the digital files for the photographs of the crime scene had become partially corrupted after you reviewed them, isn't that right?
Yes, but that was after my analysis.
But as of right now, they are no longer to anyone at this point, isn't that right?
No, they were corrupted.
So they are gone. Okay. And you said in your affidavit.
Objection commenting. May I explain my objection?
I'm going to go to Mr. Promenko first.
Yes, Your Honor. I will not comment in the future.
All right. The objection sustained. Go ahead.
Yes.
So, Ms. Kuzak, you said in your witness statement that you would prefer if there was more physical evidence, wouldn't you?
Yes, I would have.
And you also said that you were not able to recreate all of the events or the evidence that took place, were you?
No, and that's a result of not having all the physical evidence, but it's not up to me to say who or what goes where and how the evidence is placed. It happens. It just happens.
When you say it's not up to you, what do you mean by that?
I mean, I'm sorry, my words were off. I'm not there. I'm not there at the scene of the crime. I can't exactly tell the struggle to move over here or knock something down over here, or go to the other side of the residence and knock something down there, or to place the victim at a certain spot.
So in other words, a lot of the events that happened were basically you were not able to understand how they fit in with you.
No, yes, I was.
But you say that you were not able to recreate all of the events. Isn't that right?
No, I'm focusing on the main picture, the big picture, not too many details.
Okay, moving on. Did you find any fingerprints or DNA that could be traced to the intruder?
No, as seen on the videos, the intruder was wearing gloves.
And was there any way that you could possibly detect the identity of the intruder?
No, as seen in the videos, the intruder was wearing a disguise.
And wouldn't you agree that there are probably thousands of people that could possibly have similar height and build as the defendant, Avery Becker?
Objection calls for speculation.
Mr. Promenko?
Your Honor, I'm just asking the expert, Kyle Kuzak, if they would, but from their opinion, just agree that it is technically possible that could be a possibility.
Your Honor, if I may clarify my objection.
Yes.
It is not Miss Kuzak was not in fact tendered as an expert in anything besides crime scene reconstruction. This does not pertain to her area of expertise. Therefore, she cannot properly answer this question.
Your Honor, may I respond?
Yes.
I do not believe it takes an expert to just make a statement or a opinion on such a small piece of evidence as guessing it is. Inferring if there could possibly be similar heights and builds as the defendant.
At this time, I'm going to sustain the objection, frankly, based on foundation. I don't know, and perhaps she testified to it and I missed it, but I don't know that Ms. Kuzak actually ever saw the defendant.
Right. Moving on. Are you familiar with Professor Van Allen? Ms. Kuzak?
Yes, I am familiar with Mr. Van Owen.
And some of Professor Van Owen's conclusions are outside of your area of expertise, aren't they?
Yes, Mr. Van Owen is not exactly a CSR.
That was not the question. I'm asking if some of his conclusions, yes or no, are outside of your area of expertise.
Some of his conclusions are outside of my
Okay. You are not, nor have ever.
Objection, cutting off my witness.
The objection's overruled at this time. Go ahead, Mr. Promenko.
And you have not, nor have ever been a police officer, have you, Ms. Kuzak?
No.
And you said you made a witness tracking sheet, isn't that right?
Yes, I made a witness tracking sheet.
Your Honor, may I please show the jury and opposing counsel a copy of Exhibit 17?
Yes.
Could I have the technician for Exhibit 17, please?
Yes.
Thank you. Now, Ms. Kuzak, are you familiar with this exhibit?
Yes, it is my witness tracking spreadsheet.
So do you still stand by the statement you made about Avery Becker, quote, expressed remorse about prior involvement with the victim on CHS team?
Yes.
No further questions, Your Honor.
Anything else, Mr. Witten?
No further questions, Your Honor. The prosecution rests its case.
All right. First witness for the defense.
The defense calls Ms. Avery Becker to the stand.
All right. Ms. Becker, you are under oath. Please proceed.
Good morning. Please state your name and spell your last name for the court.
Avery Becker, B-E-C-K-E-R.
And Ms. Becker, what is it that you are here for today?
I'm here today because I was wrongly accused of killing my mock trial coach, Kim Brackman.
And do you participate in mock trial?
Yes,
How long have you been on the team for?
4 years.
And are you passionate in mock trial?
I love mock trial. It's my thing, and I'm good at it too.
So how would you describe from your point of view the coaching style or teaching style of Coach Brackman?
Mr. Brackman liked to have everything under his own control, under his own hands. He liked to go over all of our questions, have a very controlling kind of teacher.
Okay, so
I'm sorry.
I would object speculation, as Ms. Becker is not able to peer into the mind to say that Mr. Brackman did in fact like things a certain way.
Any response?
I respond. The defendant, Avery Becker, has had close contact with Coach Brackman since they're on the same team, and I believe that she can make a relatively accurate inference for how his coaching style was, given that they're on that Brackman was her coach for 4 years.
Certainly, and I agree the objection will be sustained just with respect to her statements about what he thought.
Yes, Your Honor.
Miss Becker, how would you describe your style of working?
I'm very much of a go with the flow kind of learner. And with for my trial, I liked to base my statements, my answers based on what the witness was saying. And so I didn't like having him, control everything. So I needed to be very, allowed to do more free.
And how is your relationship with
Our relationship was not the best.
from your experience, how would you describe his personality from what you know of him?
From what I know of him, he was a bit egotistical, I think, and he got mad more often than he could have.
Objection, Your Honor. Improper evidence.
I'm sorry, Mr. Hernandez, you cut out a little bit. Could you state that one more time?
Yes, Your Honor. Pursuant to Rule 404A, Ms. Becker is testifying to a specific character trait that Mr. Brackman had, saying that he is egotistical.
Any response?
Yes. Rule 404 states that on a particular occasion, this person acted within the coordinates of that character trait. But I believe that I'm not addressing a particular occasion. It is just a general inference for the victim's personality.
The objection will be overruled. Go ahead.
So, Miss Becker, despite this and your poor relationship with your coach for the most part, what do you think of Brackman as a coach?
Brackman did some really good things for us. He was a competitive team, and I think he was a lot of the reason that we got to state in the first place. So he did have his problems, but he also had his good points.
So let's talk about the incident with Brackman's car. What happened, and how are you feeling that day?
That was the day right after, it was our practice since getting to state at regionals, and I had gotten a best closing award, and I had gotten a best attorney award, so I was feeling pretty good. And Mr. Brackman came up to me and he started telling me once again how much more I should have been prepared. And that made me mad because I was like, I just did this good thing, so why? Yeah, so I was mad, and I grabbed I thought to be an expo marker, and I left and I drew on Mr. Brackman's car. Unintentional. I didn't want it to be permanent. I felt terrible afterwards, but I drew on Mr. Brackman's car.
And what was your mindset that day? How are you feeling after he kicked you off the team?
Not thinking properly, for sure. I was emotional and out of sorts.
And did you ever regain that sense of emotion and got your senses back together after that incident?
Yes, I did. After I realized how bad the thing I'd done was, I felt sorry, and I tried to make up.
So when we're talking about how you try to make it up with Brackman, what necessarily did you do to try to talk to him and solve the problem?
Well, I wanted to talk to him in person, so the secretary told me he was busy, and so I couldn't. And then I texted him and told him how sorry I was. I offered to get a summer job. I offered to repaint his car. I tried everything.
Now let's switch topics. Let's talk about your friend Alex Cifuentes. Do you know them? Do you know who Alex Cifuentes is?
Yes, I do.
And who are they?
They are a fellow mock trial member.
And what is your relationship with Alex?
I don't know Alex. Well, I think we're kind of rivals, I think, but we don't not good, definitely not good friends.
So how is mock trial with Alex?
I think Alex, he always, I mean, she always opened my roles, and so I feel like she was excited when I was off the team because then she could have a chance at that best attorney award at state.
So do you ever text Alex?
No, Alex would be the last person I'd ever text.
What happened at the Fry Shack on the day of March 5th, 2020?
Well, the Fry Shack is where a lot of people at CHS to hang out. And so me and Taylor had been there and we were just playing on our phones and Alex was there. And so, yeah, we were just hanging out.
And when was the last time that you remember having your phone with you on that?
The last time I remember having my phone with me was at the Fry Shack.
And what did you do about this situation after you realized that it was missing?
Well, I realized it was missing the next day. So that day, Taylor and I took the day off to go look for the phone.
Are you familiar with Blair Rollins?
Yeah.
How would you describe Blair Rollins?
Blair is Alex's, and they are about my body type, I'd say.
And do you think, from your perspective, from your opinion, that you are the only person that has the general size and build of yourself?
Definitely not. A lot of people have my general size and build.
So, do you know anything else about Blair Rollins?
About who? Sorry, you cut off a little bit.
Blair Rollins.
Yeah. So I heard that. I think Blair was the only person that hated Bracken more than I did, probably, because his father was in a case where Bracken was a judge, and
Objection, Your Honor. Lack of personal knowledge to the case that Blair Rollins suffered with Mr. Brackman.
Any response?
Yes, Your Honor. May I confer with counsel?
Yes.
Your Honor, I believe that this is a form of personal knowledge because it is what my client perceived of this incident.
The objection sustained. She's talking about something she heard about. Go ahead.
And before Mr. Brackman's death, had you ever visited his residency, Ms. Becker?
no, I didn't even know where he lived.
And finally, did you commit the murder of your coach, Mackenzie Brackman?
No, I did not.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Becker.
Captain.
Now, we can agree that you see yourself as one of the best competitors on your mock trial team, correct?
I'd say so, yeah.
You feel like you have to put little to no effort into your work for the majority of the time, isn't that right?
Mm-hmm. I have a natural talent.
However, the head coach of the CHS mock trial team, the victim of today's case, did not share this opinion.
Mr. Brackman thought I should work harder.
In fact, your relationship got to the point where you felt it right to vandalize a vehicle that he obviously cared for, correct?
My intention was not to vandalize the vehicle. I thought it was an extra marker, which would have been very easy to fix.
And yet you still vandalized this vehicle with a permanent marker, yes or no?
Yes, unintentionally.
And the reason you vandalized Mr. Brackman's vehicle was because the two of you had just entered one of your most heated arguments yet, correct?
Yes.
However, despite the argument getting quite heated, Mr. Brackman walked out and apologized to you and invited you back into practice, didn't he?
He never actually did. He started to, but he never actually said that.
But it was his intention to apologize to you, correct?
Yes.
So, we can say that the relationship between you and Mr. Brackman was rocky, to say the least. Isn't that right?
That's correct.
And later, when the victim had you taken away from the mock trial team, you texted Alex Fuentes for help getting back on that same team, correct?
I did not text Alex. I wouldn't text Alex for help with anything, like I said before.
Ms. Becker, you were here for the deposition of Detective Jordan Markowitz, correct?
Yes, I was.
And you heard him state that when you tried to get back on the CHS mock trial team and failed, you texted Alex Fuentes for help.
That is not the truth.
But you did hear him say that, correct?
Yes.
Your Honor, let the record reflect that my application is putting up Exhibit 4 that's been previously marked into evidence.
That would be fine.
Ms. Becker, here you can see, here is the exhibit of the conversation that was held between you and Ms. Fuentes. The conversation that Ms. Fuentes testified under oath that the two of you had. And in such a conversation, you said, "I'm pretty desperate to get back on. Is there any way you'd be willing to talk to the coach Brackman about having me back?" Correct?
Can you repeat the question?
In this exhibit, the Avery Becker of the conversation states, "Pretty desperate to get back on. Is there any way you'd be willing to talk to Coach Brackman about having me back?" Correct?
Yes. That's what this is a totally framed conversation. I hope you know this, but that is what it says I've said.
And Ms. Fuentes clarified that when the victim was not willing to budge over the matter, you sent her a text saying that you were going to break into and trash the victim's house. Isn't that right?
That is what it says I said.
Moving to the date of March 6, 2020, the day of Brackman's murder, you say that you were with your best friend Taylor Perkins, correct?
Correct.
You have stated that you spent that day looking for your missing phone.
That is correct.
The phone that Detective Markowitz placed near the crime scene within 2 hours from when the body was reported, correct?
Correct.
To explain this fact, the fact that Detective Markowitz found your phone near the crime scene, you say that Alex Fuentes and Blair Rowlands might have stolen your phone. Isn't that right?
I think it very likely.
And we can agree that on your own account, they may have stolen your phone to put it near the crime scene, correct?
Correct.
But half the basis for this belief is because Blair Rowlands had the same build as you. Yes or no?
Correct. Yes.
And the other half would be because Fuentes was jealous of you, correct?
I think there's more than just two parts, but yeah, yes.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor, brief redirect.
And can we take exhibit? There we go. Thank you. Go ahead.
Ms. Becker, despite this argument with your coach Brackman after the incident with his vehicle, would this ever provoke you to cause further harm to him in any way?
No, I felt horrible after I did.
And do you think, in your opinion, from what you know, can text conversations on iPhones be edited or altered?
Very easily. Yeah.
And did you ever have this conversation with Ms. Alex Fuentes?
No, I never did.
No further questions, Your Honor.
Anything else, Mr. Hernandez?
Not at this time, Your Honor.
Thank you. Your next witness.
The defense would like to call Taylor Perkins to stand.
Your Honor, this is Amanda Shepard, scoring judge. Can we have the witness state her student name for the scoring card, please?
Yes, please. Thank you.
I just changed my name on my screen.
Very good. Thank you.
May I proceed?
Yes, go ahead.
Thank you. Good afternoon. Please state your name and spell your last name for the record.
Taylor Perkins, Perkins.
Where did you attend high school?
I attended high school at Colorado High School, and I'm currently a freshman at CU Boulder.
Did you participate in any extracurricular activities while at Colorado High School?
Yes, I participated in mock trial.
Do you know Avery Becker?
I do. She's my best friend.
Were you on the mock trial team with Avery Becker?
Yes, she's the reason I did it. After school, I kind of preferred to just hang out with friends, but she decided she wanted to do this. I wanted to do it with her.
How do you describe Avery Becker as a mock trial teammate?
Avery is very, very talented in mock trial. She's just naturally talented. And oftentimes she wouldn't come with this, but she didn't really need to because she could still perform very well.
Who was Mr. Brackman?
Mr. Brackman was our mock trial coach. May he rest in peace.
How would you describe Avery Becker's relationship with Mr. Brackman?
He wasn't the best at times. They had two different views on how mock trial should be run. Or laid back and sometimes wasn't prepared, but our coach believed that we should always be prepared and we should always be working hard.
Was there ever a time when Avery was demoted to the team?
Yes, unfortunately, they had a disagreement and then Avery, and so she was demoted to the team. And because of that, I decided to also move down to B team because I couldn't be on a team without my friend.
Was Avery ever let back onto the A team afterwards?
After I refused to, was later after I stepped down because they needed us back on A team.
What happened after Avery was let back on the A team?
We went to regionals, and then she won the best attorney award and best, I believe it was closing argument for opening. Anyways, and then that's when more disagreements came.
How did Mr. Brackman respond to Avery winning the awards?
Coach Brackman was frustrated. He believed that Avery should have been working harder, and so for that he was a little bit frustrated with her.
What did Avery do in response to this?
Avery got super frustrated and then went out and without knowing drew with permanent marker on Coach Brackman's Porsche.
Did Avery ever apologize for this vandalism?
Yes, multiple times. She's very sorry for what she did.
After she apologized, did Avery ever attempt to get back onto the team?
Yes, she tried many times, but it didn't work.
Do you know Alex Fuentes?
Yes.
How do you know Alex Fuentes?
Alex Fuentes is one of the other, was one of our teammates on mock trial. We're very good friends with her. Her and Avery didn't really get along very well.
From your perspective, do you find it likely for Avery to contact Alex to get back on the team?
Very likely, but she was in a state.
Did Avery end up getting back on the team?
No.
Did Avery ever make any further attempts to set things right with Mr. Brackman?
Yes, on one practice, but again, they got in a dispute, and Brackman turned her away.
Can you describe to us what happened at the Fry Shack on March 5th, 2020?
Yes. So after we left on Thursday, we went to my house and we hung out for a little bit, and then we decided to go to the Fry Shack. And we were there, and then some of our other teammates came, and Alex was also there.
Did Avery ever at any point leave their phone?
Yeah, so we were talking to Alex, and Avery got pretty frustrated, and so she left and left her phone.
Who was the last person you saw using Avery's phone?
Alex. When Avery left, I was talking to Alex. She was just talking about how she was so that Avery was like, she wanted to get her Avery back on the team, but I could tell that she didn't really mean it, and I times even wanted to just punch her in the face.
After you left the Fry Shack with Avery, when did Avery notice that her phone was missing?
The next morning, I believe.
And were you and Avery together on the day of March 6, 2020?
Yes, we were all day. We already taken some of our quizzes before in the week, and so that day was pretty dry for us, and so we decided to spend the day looking for Avery's phone.
And you were with Avery that whole day, correct?
Yes.
Did you?
Sorry.
I'm sorry, I shouldn't have cut you off. Did you or Avery at any point go anywhere near Mr. Brackman's house on that day?
No, we didn't even know where he lived.
And did Avery ever at any point have her phone after you went to the Fry Shack?
No.
Thank you. No further questions.
Any cross-examination?
Yes, Your Honor. Good afternoon, Ms. Perkins. You testified that Miss Becker and your former coach had a difficult relationship, correct?
Yeah, it was a little rough at times.
And this was because Mr. Brackman believed Miss Becker did not put enough time into mock trial, yes or no?
Yes, they had different views on how it should be run.
Therefore, her lack of time spent on mock trial affected the team, correct?
A little bit, but not much. She's still very naturally talented, so she's still very good at what she does.
Moving on, you also previously stated that Miss Becker was kicked off the team after an incident with your coach's car, correct?
Yes, unfortunately.
And this was because Miss Becker wrote worst attorney award on your coach's beloved Porsche, yes or no?
Yes, it was an accident though.
You've previously mentioned that Miss Becker could be rash. To the best of your knowledge, do you believe her decision to write on your coach's beloved car with a permanent marker was a rash decision?
From my best knowledge, it was out of her mind. She was at a rough place because she was very frustrated, and so it wasn't very often that she would do things like this. But she was at a tough place.
So was that a yes to my question?
Yes.
And you believe Miss Becker being kicked off the team was a punishment for her vandalization of your coach's car? Yes or no?
Yes.
So to clarify for the jury, Miss Becker was kicked off your team by Mr. Brackman as a punishment for her vandalization and rash decision, yes or no?
Yes.
Moving on, you mentioned that Miss Cifuentes and Miss Becker were not the closest of friends, correct?
No, they were not.
But you did know that Miss Becker planned on contacting Miss Cifuentes, yes or no?
I did not know that she planned on contacting her.
You claim that you did not know Miss Becker was planning on contacting Alex Cifuentes, even though in Kyle Kuzak's interview, it claims that you testified to this relationship in these text messages?
I might have had an idea that she was going to contact Alex.
And Miss Becker, if she did contact her former teammate, was trying to get back onto the team, correct?
Yes.
But as you previously mentioned, Miss Becker never mentioned her conversation with Miss Cifuentes to you, true or false?
True.
Therefore, you have no reason to say that these texts are inaccurate when you do not know the details of their conversation, yes or no?
Yes.
Ms. Perkins, you previously stated that you did not know the location of Mr. Brackman's house, correct?
I did not know at the time.
Are you claiming that after the incident you found out the location?
Yes, because we heard about Brackman's death.
You and Miss Becker skipped school on the day the murder took place, correct?
That is correct.
You claim that you were with Miss Becker the entire day the murder took place? Yes or no?
Yes, you could track my phone, but the police never did that.
However, you and Miss Becker both had first period off, and that's why you rode together, correct?
Yes, we always drive to school together.
Therefore, you cannot actually account for Miss Becker's whereabouts in the morning before she picked you up for school, yes or no?
That is correct, yes.
So you were not actually with Miss Becker all day, correct?
For the majority of the day I was.
That's a yes to my question.
Yes.
Moving on, would it be accurate to say that Miss Becker felt angry and disappointed about being kicked off the team?
Yes, absolutely.
And you stated previously that you felt your coach's decision was unfair, correct?
Yes, because Avery was still a very valued team member.
So to the best of your knowledge, Miss Becker had many mixed emotions about your coach after his decision to remove her from the team, correct?
Yes.
And Miss Becker's previous rash decision was also when she had mixed emotions about your coach's unapproval of her work ethic, correct?
Sorry, will you say that again? You cut out.
Miss Becker's previous rash decision with the former car vandalization was also when she had mixed emotions about your coach's unapproval of her work ethic, correct?
Yes, however, she didn't know it was permanent marker at the time.
Finally, Miss Perkins, do you believe Miss Becker's mixed emotions about your coach's decision to remove her from the team, to the best of your knowledge, could have caused her to make a rash decision like the former car vandalization?
Objection, speculation.
Any response?
Yes, Your Honor. This is not speculation pursuant to Rule 701. This is proper lay witness testimony, rationally based on the witness's perceptions and observations from knowing Miss Becker.
The objection sustained. Go ahead.
However, you do claim that Miss Becker was angry at Mr. Brackman after removing her from the team, to the best of your knowledge?
She was frustrated, yes.
Thank you. No further questions.
Any redirect, Mr. Flanagan?
Yes, I have a brief redirect.
Okay.
Taylor, Avery was consistently apologetic and remorseful after the vandalism of Coach Brackman's car, correct?
Absolutely. She felt so bad.
And do you believe that Avery would ever attempt to harm Mr. Brackman?
Absolutely not. She's my best friend and she would never do something like that.
Thank you. No further questions.
Ms. Burton, any recross?
No, Your Honor.
Your next witness.
Your Honor, the defense calls Professor Blake Van Owen to the stand.
All right. Professor Van Owen, you are under oath at this time. Please proceed.
Good afternoon. Please state your first name and spell your last name for the record.
Blake Van Owen, Van Owen.
And Professor Van Owen, what is your profession?
I am a professor and a private investigator.
And what is the extent of your education in this area?
Yes, I received my master's degree in criminal justice from the Ashford University.
And how did your experience with law enforcement begin?
That would have had to begin at my time as a police officer at the Aurora Police Department.
And how did that end?
It ended with an accident I had with a woman of color during an arrest, and I later quit.
And how did that incident end?
It ended with me obviously quitting from the police department, not because I was fired, but because I was disciplined in a number of police practices and procedures.
And after you left the police department, what did you do?
I went on to become a private security guard, a school resource officer, and now a private investigator. I also teach a couple of classes. Yeah.
And what is your experience with testifying as an expert?
I have testified as an expert on over 100 cases, mostly regarding crime scene reconstruction, power analysis, and general police investigation tactics.
And what expertise and or training do you have that pertains to today's case?
In today's case, my expert training, I have obviously had my education through Ashford University. I've been accepted as an expert in the district courts of Colorado, Kansas, and Arizona, with the state courts of Colorado, Nebraska, New Mexico, and Wyoming.
Okay, Your Honor, I move to admit Professor Blake Van Owen as an expert in police procedure with additional knowledge of general police investigation tactics, which include crime scene reconstruction and cell tower analysis.
Any objection?
Yes, Your Honor, I object to the the cell tower data, as the witness has not yet testified to any specific information about any training or experience that they have in that field. I would be more than happy to waive my objection if they could lay foundation as to what specific training they have.
Mr. Goldberg?
May I lay that foundation?
Yes.
Mr. Van Owen, what education and training do you have in the area of cell tower analysis?
Yes, so through my master's degree in criminal justice, that degree covers a wide umbrella of fields and categories. And I've also gained plenty of experience through just overall time being involved in this career as a private investigator and through all the knowledge I've gained through police practices. And through all that, I've been able to learn about the different sectors, what different towers do, their mileage, their radiuses, and differences between what type of towers correspond to like a rural area versus a urban area and so forth.
And how many times have you been accepted by a court as an expert in cell tower analysis?
Over 5, or about 5 times.
Okay, thank you. I move to admit the witness as an expert in the fields listed.
Mr. Quinn?
I still believe that, not detective, Mr. Van Owen has not met the minimum requirement for training or expertise in cell phone data that would be probative to the trier of fact in today's case.
Any response, Mr. Goldberg?
I stand by the foundation that my witness has laid.
At this time, I will overrule the objection and allow you to express expert opinions in police procedure, general procedures, including crime scene reconstruction and cell tower analysis. You'll be allowed to express expert opinions in those areas.
Yes, Your Honor.
Thank you. So, Mr. Van Owen, what brings you here today?
The death of Mr. Mackenzie Bracken.
And have you been asked to offer any opinions on the investigation to his murder?
I have. My opinions on this case regarding his murder are that no one can say to a reasonable degree that Mr. Mackenzie Bracken was stabbed in the midst of a struggle. It is rather more likely that he was stabbed in the back, caught unaware. Secondly, no one can prove through evidence that the suspect, Avery Becker's phone was at the location of Mr. Mackenzie Bracken. And even if the prosecution were to prove this, no one can prove that Avery Becker herself was at the crime scene. And finally, the prosecution's case is methodologically unsound.
So why does the cell phone tower data not accurately prove that Becker was at the crime scene?
Yeah, so let's first take a look at cell towers. A cell tower, especially if it's in a rural area, can cover up to 100 miles. However, a cell tower in an urban area, that can cover about 6 to 7 miles. Now, what a cell phone will do is it will connect to the cell tower that usually has the best coverage. So while a cell phone could be right next to a cell tower, it could potentially connect to one way, given that other tower would have the best network. This information, we have no way of saying that Avery Becker's phone was near Mr. Mackenzie Bracken's house, given the cell towers don't give us that information.
And why was Mackenzie Bracken most likely stabbed from behind?
Let's take a look at the knife construction and the characteristics and aspects of the wound. Mr. Bracken was stabbed in the aorta through his scapula. For one to get that far and to have been standing, as the prosecution says, the suspect would have had to have been significantly bigger than Mr. Bracken. However, going from the ring recordings, we know that the suspect was not that much bigger than Bracken. So based off what we can gather there, the only possible way for Mr. Mackenzie Bracken to have been stabbed in the aorta and for the victim to have not been significantly bigger than Mr. Bracken is that he would have to be stabbed. And this is significant as it indicates premeditation to commit the murder.
Objection, speculation.
Any response, Mr. Goldberg?
I don't understand counsel's objection. What is my witness speculating?
May I respond?
Yes.
Your Honor, this is speculation as Mr. Van Owen had just testified that there would have needed to have been motive, and that is outside the realm of his expertise. He has only been qualified to testify as to what the injuries show, and he cannot testify as to whether or not there was motive just based off of the stab wounds.
Anything else, Mr. Goldberg?
The information he provided goes to the weight, not necessarily the admissibility of the evidence.
The objection sustained.
I ask that all testimony regarding motive be stricken from the record.
So done. Thank you.
Yes, Your Honor.
Mr. Goldberg?
And why is the prosecution's case methodologically unsound?
There are a number of reasons which point me to this conclusion. First is Detective Markwitz's failure to obtain the complete cell tower records pertaining to Mr. McKenzie's death. He only subpoenaed the records from around the time of his death, not before, not after. And given that, we have no way to confirm where the suspect's phone was between those periods of time, before and after. And secondly, Mr. Mackenzie Brackman only got the cell phone records for the Avery Becker. The better practice would have been to obtain the cell.
Objection narrative.
The objection's overruled. Go ahead.
Sorry. The correct practice would have been to have obtained the cell data records from all the cell phones in the vicinity and see if there's any correlation between those different cell phones and Mr. Brackman. That's the first reason that points me to why the prosecution's case is methodologically unsound. The second reason is that the prosecution, and especially the police department, they just blatantly accepted the screenshots of Alex Fuentes' phone. And for all we know, those screenshots could be doctored. There's no way to verify that those screenshots were true and accurate.
So in your opinion, as an expert in police procedure, what are your conclusions about this case?
My conclusions for this case, and I've been an expert witness in over 100 cases, I'm very familiar with this. I can come to the conclusion that the prosecution's case was rushed and that they went for an easy conclusion.
No further questions, Your Honor.
Cross-examination, Mr. Whitten?
Yes, Your Honor, one moment.
All right.
Good afternoon, Mr. Van Owen.
Good afternoon.
On direct, you talked an awful lot about your CDR training.
Yes, I did. Depends on your definition of a lot, but.
And nowhere in your affidavit do you mention any of this specific training?
Not within my affidavit, no.
And you also got very, very specific with the ranges and types of cell towers.
Yes.
And nowhere in your affidavit do you even mention the ranges of cell towers, nor do you mention the different types.
Within my affidavit, I do mention the ranges of the cell towers.
You do not mention the different types of the cell towers?
Not the different types, but different ranges.
So that's a yes to my question. You do not mention the different types of cell towers in your affidavit.
Specific types. I did mention the difference between the ranges.
You used to work for the Aurora Police Department?
For a short 9 months, yes.
And since then, you've become a private investigator and a professor?
I have.
And your job requires that you testify in court?
Yes.
However, you have only ever testified on the side of the defense. Is that correct?
For good reason, yes.
Now, you are paid by the defense for your testimony today, aren't you?
Objection, Your Honor, relevance.
Any response, Mr. Witten?
Your Honor, this is proper cross-examination to the quality and credibility of this witness. The fact that they are being paid by the defense goes directly to their credibility.
The objection's overruled. You may answer.
I am being paid to be here today, yes.
Now, let's talk about the many conclusions you came to in this case. I'd like to start with your idea of what happened at the beginning of the break-in. You claim there is little evidence of a struggle?
Yes.
You believe this because we don't have a before and after of the crime scene.
I'm sorry, but can you be more specific on before and after? I don't quite understand.
In your affidavit, you state because we don't have a before and after of the crime scene, it's difficult to tell when the scuff marks were there because we cannot date them.
Like before and after photos?
Yes.
Yes, there was no photos of the scuff marks before and after, and there's no...
So that's a yes to my question. Because we have no before and after, you cannot tell if it's a break-in. There was a break or a struggle, excuse me.
We have no before and after photos.
Are you aware of what Exhibit 9 is?
Exhibit 9, would that be the photo of the scuff marks?
No, Exhibit 9. Are you aware that a broken plate was found at the scene of the crime?
Objection, Your Honor, that's not in evidence.
Mr. Witten?
Your Honor, I rephrased my question to not introduce facts that were not in evidence. Mr. Van Owen had testified to knowing all of the facts of the case and had reviewed them. So I'm simply asking if he's familiar with the fact that there was a broken plate on the scene at the scene of the crime.
The objection sustained. You can ask him if there is one and if he knows about it.
Yes, Your Honor. You were aware that there was a broken plate, yes or no?
I was not aware, no.
You never went to the scene of the crime, did you?
No.
But Ms. Kuzak and Detective Markowitz did?
Yes.
And a lot of what you say in your affidavit contradicts what Ms. Kuzak and Detective Markowitz testify.
Yes, given the quality of the job they performed.
Now, let's move on to what you think happened when Mr. Brackman was stabbed. You believed he was sitting down when he was stabbed?
Based off the evidence in the ring videos that show the size of the suspect, that is the conclusion that I can come to, yes.
So that's a yes to my question. You believed he was sitting down?
I do believe he was sitting down, yes.
So he must have been surprised when he was stabbed, yes or no?
He would have had to have been surprised, yes.
And the back door leads directly into the kitchen?
Yes.
And Mr. Brackman would have been sitting in the kitchen?
Yes.
I'd like to talk about the Ring app. You disagree that the Ring app would have alerted Mr. Brackman, as he could have simply turned notifications off?
Yeah, there is no way to see if Mr. Mackenzie Brackman had those I'm sorry, we have a announcement.
Your Honor, I ask that time be stopped for this technical issue.
That request is granted.
I apologize, those announcements are now over.
Mr. Kuzak, You think that Mr. Brackman could have simply turned notifications off, yes or no?
It's possible, yes.
However, you never searched his phone. Is that correct?
No, and neither did Mr.
So that's a yes to my question. You never searched Mr. Brackman's phone.
No, not personally.
So you don't know whether or not he had notifications on.
No.
You don't believe that Avery Becker committed this crime, do you?
I just don't believe that there's enough evidence to prove that she was guilty.
So that's a yes to my question. You don't believe Miss Becker committed this crime?
I really have, in my personal opinion, I would say no, just because we don't have that evidence, no.
So then let's talk about another possible suspect. You believe it could have been Blair Rollins?
I do.
However, the only evidence you have for this is that Blair Rollins was not at school that day.
That is correct, and that his body size.
And neither Miss Becker nor Miss Perkins were at school that day either, were they?
No.
Thank you, Your Honor. No further questions.
Any redirect, Mr. Goldberg?
Briefly, yes. Okay. What other information do you have that Blair Rollins could have been the murderer?
Well, based off the attendance records and the conversation with Avery Becker and Taylor Perkins, he was about the same body size as shown.
And no further questions, Your Honor.
Any recross, Mr. Wynn?
No, Your Honor.
Thank you. Does the defense rest?
Yes, Your Honor, the defense rests.
Closing arguments.
Yes, Your Honor. But first, may I ask to reserve any remaining time for a rebuttal?
Yes.
Thank you, Your Honor. May it please the court.
Yes. Please proceed.
In the back. Members of the jury, Mackenzie Brackman was found just outside his door in a pool of blood with a knife wound in the back. Mackenzie Brackman was a dedicated member of society. He put forth movements to bring justice to those who needed it and put forth extra time and effort to teach young adults the very practice that can save many from unjust punishments. But because he made strokes to prove the obvious talent in a young pupil, he was made the victim of a cruel and devastating murder with a knife in the back. A history of conflict has been made clear between the defendant and the victim. They had argued in almost every one of their practices, and when the victim had deemed it worthy that the defendant be removed from the CHS mock trial team, the defendant acted out and wrote Worst Attorney Award across the hood of the victim's precious 1986 Porsche vehicle, and she did so with a permanent marker. The victim was let go from the CHS mock trial team for good, but the defendant was not ready to accept this. Ms. Becker reached out to Missy Fuentes, who has testified under oath today, and asked for a chance to get back on the team. The victim did not allow Becker back on the team. As a result, the defendant wrote to Missy Fuentes saying, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. That single phrase, along with multiple strings of evidence, placed Avery Becker at the scene of the crime. Today you heard from Alex Fuentes, who spoke to the rigid and aggressive relationship between the defendant, Avery Becker, and the victim, Mackenzie Brackman. You heard from Ms. Kyle Kuzak, who was able to illustrate the state of the crime scene in vivid pictures, and how that same crime scene correlated to a trashing that the victim had mentioned in a stream of text messages with Alex Fuentes. You heard from Detective Jordan Markowitz, who began this hearing with a stream of strongly supported evidence that point to 1, Avery Becker. The prosecution holds the burden of proof in today's case. We must prove to you beyond a reasonable doubt that Avery Becker committed second-degree burglary and murder in the first degree on the date of March 6, 2020. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence. If you find the evidence and each element of the crime scene has been proven, you must find the defendant guilty of such crimes. Members of the jury, today my co-counsel introduced ourselves by saying that we would prove Ms. Becker committed both murder in the first degree and burglary of a dwelling. With the testimony given in these past few hours, we have met that burden. With the testimony given in these past few hours, we have shown you that Mr. Brackman was left alone in a pool of blood with a knife in the back. This betrayal was brought on by a single person. That one person is Avery Becker. Vote in the name of justice. Find the defendant guilty. Thank you.
Closing argument for the defense?
Yes, Your Honor.
Thank you, Mr. Promenko. Go ahead.
The feeling of blame, the weight that one carries on their shoulders when this feeling is forced upon them can be frustrating and maddening. That kind of pressure is hard enough, but it is almost impossible to imagine those feelings magnified to a level that we find ourselves in today. As jurist William Blackstone once said, it is better that 10 guilty persons escape than one suffer. Your Honor, ladies and gentlemen of the jury and opposing counsel, today you have heard from the prosecution, who have impatiently jumped to the conclusion that Avery Becker was the one with full responsibility for the death of former mock trial coach Mackenzie Brackman. First, from Detective Markowitz, we see that he fell short of doing a complete investigation and failed to check alternative leads on this investigation. Kyle Kuzak, who admittedly would have preferred more evidence, could not be 100% sure of his findings, and some of which he discovered in his affidavit to have been corrupted after his analysis. Again, it is better that 10 guilty people escape than one suffer. Now, about Alex Cifuentes and the alleged texts that they received from Avery Becker. Even though Avery said Alex would be the absolute last person she would contact. This incompetence and dishonor should by itself be enough to prove the defendant's innocence. But there is still more. The prosecution only admitted one piece of evidence throughout the whole trial to convict the defendant Avery Becker of this murder. So now, why don't we listen to the people who really knew Brackman best, who knew Avery the best? Those people would have to be Avery Becker and Taylor Perkins. Avery Becker is a competitive student, and just like many other students who share Avery's passion in mock trial. Sure, Avery had a little emotional breakdown when she was kicked completely off the team, something that she cared very much about. But to relate that to murder is just completely absurd. All the emotions aside, Avery has presented valid evidence as well as an alibi to prove that she was in no way responsible for the break-in and death of her own mock trial teacher, Mackenzie Brackman. From her loyal best friend, Taylor Perkins, who was with Avery the whole time during these events, has provided a witness that the alibi provided by Ms. Becker is true and provided evidence that Avery did not have possession of her phone during the period of time in which the alleged text messages were sent to Alex Cifuentes. And finally, from the expert witness, Blake Van Owen, he covered up all the loose ends that Markowitz missed, such as the possibility of an alternative suspect, and addressed the idea that the knife could possibly not have been from Brackman's house, which it was not. Your Honor, ladies and gentlemen of the jury, today you are faced with an important decision, one that will determine the future of an innocent student. I want to restate that the defendant is innocent until proven guilty. And with all you have seen and heard today, I do not believe that there was any adequate evidence provided by the prosecution in order to find Ms. Becker guilty of the murder of Mackenzie Brackman. Thank you for your time.
Thank you. Mr. Hernandez?
Yes, Your Honor. Before I begin, may I inquire as to how much time I have remaining?
Yes.
You have 1 minute and 16 seconds left.
Thank you. May it please the court.
Yes, go ahead.
Carrying the weight of the world. Today, ladies and gentlemen, you heard from Miss Perkins. And you heard Miss Perkins say that she was not with Miss Becker for the entirety of the day to account for her actions on March 6, 2020. You heard from Mr. Blake Van Owen, who testified to the fact that he is being paid to testify here today. And to begin the defense's trial, you heard from Miss Becker, who said that she did everything she could to make things right with Mr. Brockman. But remember, Miss Becker was a top mock trial student who knows what the jury wants to hear. This weight does not just rest on the defendant, but now on you as members of the jury. A weight that can only be reached when you find the one guilty party guilty. And that one guilty party is Avery Becker. Thank you.
Thank you all. At this time, we'll allow the scorers to compile their scores. We'll take just a short break until they are finished, and then we'll have some comments once they are done. So for the scoring judges, please let me know when you've finished.
Judge,
Yes.
is there no opportunity for us to go to a separate room away from the participants?
Well, let me just see. We have a breakout room. Let me see if I can do this on this. I'm not totally familiar with Zoom, so let me see what I can do here.
I've just got a little bit of difficulty in keeping some of these names straight on my score sheet, and I thought if we were able to confer with one another, that might expedite things.
Sure. Let me just hang on. Let me make sure that I have the right people who I would be putting into this. So my apologies. So I believe that the designation that you have is Mike.
Yes.
Sky. And I don't recall the third.
Amanda Shepard.
Okay. Were you getting ready to say something?
No, I wasn't. I was just going to say it's me, Your Honor, Amanda Shepard. Sorry
Okay.
about that.
No, not a problem.
And I did submit my scorecard already, but I do have it printed so I can assist with the names.
Okay.
Amanda, can I ask you, how do you there's a submit button at the bottom of page 2, isn't there?
Yes.
Right.
Okay, so so I'm gonna do 3 minutes, and then you'll get a 30-second countdown. Does that sound okay?
That sounds sufficient.
That's fine with me.
And if you need more time, that's fine.
Okay. Are you breaking us out, or are we just gonna?
Well, I think you're gonna go, well, my intent is for you to go to a breakout room. But I'm struggling to find where I started.
Oh, there we go.
Oh, did that do it?
I just got a dialog box. Your host is asking you to join a breakout room.
Okay, so go ahead and click on that.
Well, it's gone now.
Oh, okay, how about now?
Yeah, it's there. It's good. Okay.
Okay, if anybody else got that same invitation, don't go. Okay. All right, I believe everybody is now back.
Yeah, I believe Mike needed some additional time. I don't know if we can request that and get back in there. He was having a fair amount of difficulty with the scorecard.
Sure. Okay, so give me an idea on how much time.
Can you? I think we just got to the point where we can do it in probably another 3 minutes, if that's acceptable.
Oh, yeah, I agree.
Okay,
Great.
I think you should have that.
Great, thank you.
Thank you. All right, did that provide sufficient time?
I guess so.
Well, I now know how to do it, so I can give you more if you need it.
No, it's all right, Judge. I think it'll be okay.
Yeah, now that I've done it twice in a row, I feel like an expert.
Oh yeah, you did a great job with the breakout.
Yes, you did.
You seem to qualify that only to the breakout, so.
Oh no! Are you kidding?
No, I'm just kidding.
Oh yeah, all the way through. Great
All right. So now it's time for the after chats. I'm gonna go ahead and allow the scoring judges to go first. I'll go last. That way I don't say any of the same things over again. So I'm just gonna go in order of the squares that I have. So Mike, do you wanna go first?
Oh, if you force me to, Judge.
Okay, well, just realize you only have like 2 minutes, so.
Oh, good. That's excellent because I'm not going to use any part of that.
Okay.
I think everybody did a fabulous job. I thought that your command of the facts was really exceptional on both sides, and I was really impressed with your use of the rules. That tends to be one of the most arcane aspects of our profession and our work as trial lawyers, is being able to come up with arguments when those objections are thrown at you and you're forced to respond in some fashion. So kudos to all of you who were able to exercise a command of those rules of evidence. I would say that the other comment I would make, and this is just for future reference. I mean, it's the showmanship aspect is not nearly as important as your command of facts and law. So tone down the hand gestures and sort of what you think we want to see from television. What we do is actually far from television for the most part. But anyway, I think all of you did a great job.
Amanda?
I got it figured out. I just wanted to say you guys all did an absolutely fantastic job. I know given the circumstances, this isn't ideal. It would be nice to be in the courtroom with the fabulous judge here, but you did a great job. I think a special shout out to your trial technicians and your timekeepers. I know that's a very underappreciated part of it, but very crucial. You guys did a fantastic job there. The witnesses, way to go, way to get into your roles and really play those. It was easy to follow along and, very well structured. You guys all just did an absolutely fantastic job. And I would say going forward, just like Mike said, keep in mind staying on point. One thing I was really impressed by was your use of objections and being able to know the rules of evidence really well. That's really a crucial piece of doing this, as you all know. So just an absolutely fantastic job, and thanks for giving us something fun to watch this afternoon.
Sky?
Yes, I would just echo what Mike and Amanda said. I think you guys were amazing. Congratulations doing this on WebEx or Zoom or wherever we are right now. Holy moly. That was incredible. I really appreciated that you guys, made this your own and commanded the environment that we were in. So really great work, you guys. And I was super impressed by both sides. So thank you.
Well, I took copious notes, so I'm going to take more than the 2 minutes. It'll be more like, I'm just kidding. I'm not going to do that. I really echo all of the things that the other scoring judges have already said. You guys clearly put a lot of work into this. All of you did. It really shows when you are able to get into character, you're engaging. It's very good. I do have some specific things, and that is one of the objections that I sustained was, Mr. Winton, a question that you had asked. And right after that, the defense almost asked a very similar question. Make sure that for all of you, you're listening to what not only your witnesses are saying, but also the questions that are being asked. Because if you had come back, Mr. Winton, with the same question, I would have let you ask it at that point. So make sure that you're not only listening to the answers of your witnesses, because you clearly all were, but also the questions that are being asked by opposing counsel, because sometimes you may be able to go ahead and ask your question again if they're going back to something similar. So I just wanted to bring that up. One of the things that I see a lot in criminal cases is something that was similar to here, but a little bit different. What I see a lot is an attack on the investigation, and here it was couched as the prosecution's case. So when you are in trial, and hopefully you all will get older and go to law school and become lawyers, because you're all great. But you will not go after your opposing counsel because, frankly, they will establish a rapport with the jurors. You want to go after their witnesses or the basis for their opinions, as opposed to the opposing counsel, because you can turn some of the jurors off. So just kind of keep that in mind. I can't even imagine trying to do this via Zoom like we did, particularly with the ubiquitous bells going off during some of the testimony. You guys did a great job staying on track, and I'm really impressed. So that's as far as I'll go at this time. And again, great job. Thank you all so much for participating in the mock trial this year, even through these hard times. We appreciate it all, and it's great to see everybody's faces, even though they're in these little itty bitty boxes. So anyway, thank you all so much.
Thank you.
Thank you.
Thank you. Thank you.
I guess I'm supposed to get out of here now, huh?
Well, I just sent
everybody just like went away. So I'm like, I guess we're gone now.
I know.
Judge Robinson, you did an absolutely fabulous job. I think I've seen you a couple of times in court before, but you're just incredible.
Oh, well, you're very kind. I really appreciate it. Thank you so much. It was really an honor to do this, so I appreciate it.
Absolutely. You have a nice day and nice weekend.
Thank you. You too.
We'll see ya.
Bye-bye.